Here come the judge.
Happy New Year, lawpickers. May you win all your legal cases in 2025, if you deserve to, and may you get more than a little bit of help from the return of Breaking Law, the book What I Wrote.
Would it be a good idea to buy up all copies available so that opponents won't benefit from your legal tips?
A great idea, but could you hold 2 copies back in stock, one for your piranha and one for me? I've worn my copy out. I couldn't stop reading it. Compensation for a whiplash injury in a road traffic accident. That's a soft tissue injury job to the neck, the back or the shoulder. Well, it's pretty mean. You get a fixed amount depending on how long it takes for your symptoms to clear up. For example, for the injury itself, you're scored £240.
£240? You must be joking.
Hold on. I always give at least 24 hours prior notice before telling a joke so that you can prepare. Now, the £240 is for where symptoms clear up within 3 months. And there's an extra £20 thrown in if you've suffered from one or more minor psychological symptoms. Oh, and a 20% enhancement in exceptional cases. Now, if the whiplash was accompanied by some other injury, then that will be compensated for on top. The government has been looking at whether changes should be made to this scheme. It's now announced that the only change will be an inflationary one. The fixed figure will be increased by between 14 to 15%. Stand by for legislation to bring that into effect, but don't postpone making a claim so as to be able to take advantage of the increases. They will only apply to accidents that occur after the legislation comes into force. On the 1st of October last year, you probably had a celebration, didn't you? Dancing round your car with flags and party blowouts.
Was it your garage's birthday?
No, it was the day of the announcement that a new code of practice had been introduced covering the issue of parking tickets on private land. We're not talking here about parking misdemeanours on the street, which are within the remit of the police or the local council. We're talking about parking within, say, a shopping development, a supermarket's grounds, the back of a block of flats, that sort of location, and about overstaying, failing to display a ticket or permit, parking skew width partly outside the markings of the bay. The code of practice was the work of the 2 car parking trade industries, that's the British Parking Association and the International Parking Community, and it was presented as the best thing to have happened to motorists since they invented brakes.
Wasn't it?
No. The best thing would have been the code of practice which was proposed by the previous government, which it had been required to propose thanks to a 2019 Act of Parliament. Among other things, that code would have capped penalties at £50 a time, or £80 in London, and required a 50% discount to be given to motorists if they settled up within a fortnight. But the industry didn't like it. It would have cost them too much money. Well, a group of private car park operators started legal proceedings to stop that code being implemented. The government took fright and the draft code was withdrawn just 4 months after it had seen the first light of day.
So where does this 1st of October code come in?
Well, it's a deaf move by the operators through the trade associations to stop or delay the new government from coming up with a revised code, which they should have been doing. The trade associations issued their own code. Well, the trade code is a much weaker version of the government code, and the operators, nevertheless, are meant to follow it. The code allows for a penalty of up to £100 in and out of London, a discount of 40% for early settlement, it's unlikely to be exceeded, and for an administration charge of £70 to be added on to the penalty if payment is made but made late.
Anything good?
Well, no ticket is to be issued within an overstay of just 10 minutes, so that doesn't apply to short stays of up to half an hour. And the code recommends that a parking ticket should be cancelled where it was issued because you were required to input your registration number but you got the number wrong. You made a minor keying error. If you made a major keying error, like inputting the right registration number, but for your old car, they recommend a penalty reduction to £20 and down to £20 as well if you've overstayed because of the onset of an illness or a medical appointment overrunning, or the payment machine was out of order. There was no alternative means of payment available, and you couldn't reasonably have been expected to have accessed any other machines in the car park that were operational. In short, if some aspect of the code has been broken, the penalty should be either cancelled or reduced.
So who decides whether the ticket should be cancelled or penalty reduced?
Well, glad you spoke. I thought you'd gone out to find a parking machine. You appeal to the car park operator within 28 days of getting the ticket. Now, that time can be extended if there are exceptional circumstances. But watch it. There's a risk that you will forfeit the discount for paying up within 14 days if you do appeal. And should that appeal fail, you can have a second bite of the cherry by appealing to the independent appeal service available from each of the two trade associations. And you've got to do that within 28 days of rejection of the first appeal. No charge for either appeal. One big point. The code will only apply if the car park operator belongs to one of the two trade associations. The others may continue attempting, and often succeeding, to be cowboys. Most operators will belong.
Why is that?
Well, with probably the majority of parking tickets, they are issued without the operator having a clue of the driver's identity. Very often, the vehicle's number plate will be snapped coming in and going out. The parking ticket will then be sent out to the registered keeper, who will be responsible for payment unless they weren't driving and they grasp on who was the actual driver.
And how does the operator discover the identity of the registered keeper?
Well, we go to the DVLA and say, here's £2.50, give us that information, and they get it. But they will only get it if they're members of one of those two trade associations behind the code.
Cool.
If you think so.
Now, what happens if the code applies and you lose both appeals, or the code does not apply and the operator insists on you paying up?
Well, the operator then would have to see you in the county court and you could defend the case. You'll find out about the various defences you could put forward in my book.
The Return of Breaking Law.
Why, yes. Strictly speaking, just breach of a code, pure and simple, wouldn't be a valid defence in the county court, but the code may have raised some other factor that could be the basis of a good defence under the common law, such as that the car park signage had been hidden or was insufficient so that you couldn't have been taken to know what were the rules of parking in the park.
And when will we see a revised code from the government?
Well, the other month I was told in due course, then the other week the House of Commons was told soon. And they need a bit of encouragement by way of a boot
Up their backside.
or their exhaust pipe. Now, a plucky 85-year-old, Stanley Luckhurst from Gerrard's Cross, who had a parking ticket success in the county court in central London, has presented a petition to the Commons for the government to produce the revised code. You can go online to support this petition if so inclined at this address.
And where can you find the Trade Association's code?
Here. The two trade associations have just announced that in February 2025 they'll be changing their code as to address difficulties experienced by drivers in being able to make necessary payments, and also that a full review of their code can be expected in April next. Now, last December, XL Parking dropped proceedings against a woman who had accumulated a bill of £1,906 in parking tickets after it took her more than 5 minutes to pay for her parking each time in a Derby car park. She collected 10 tickets in the space of several days, having walked away from the car park to find phone reception so that she could use an app to pay for parking in her bay. And that experience is behind one of the reasons that the trade associations are having another look at their code. Take this scenario. You've got a solicitor acting for you in a civil court case. They tell you in advance what they'll charge you for acting, probably so much for each hour they're occupied on the case in and out of court. And that amount will mainly depend on the complexity of the case and who will be dealing with the case in the solicitor's office, the office cat or the boss who's been at it since Gone with the Wind went on general release. Well, with a bit of luck, you'll win the case and the other side will be ordered to pay your legal bill. So you will enjoy reimbursement of what you have paid over to your solicitor. Well, in deciding the actual amount the other side has to pay, the court will follow guidelines which are looked at, they're reviewed annually. Your solicitor can be expected to reflect those guidelines in what they charge you, although they could charge you more if you agreed to pay higher rates. Well, for work done after the 1st of January this year, the guideline rates have been increased by 3.65%, and that's just to take account of inflation since they last went up. Exactly what the rate would be depends on where the solicitor's office is situated. So don't be surprised if you get a communication soon from your solicitor to tell you that they'll be charging you up an extra 3.65% an hour for future work, though of course you will hope to get that back, or some of it, from your losing opponent.
Can you give us an idea of what sort of hourly figure the increased guidelines recommend?
Of course. But it will cost you £1,000 an hour for me to work it out. Joke alert. The top earner, say, would be a senior solicitor in central London acting on a very substantial commercial or company case. The hourly rate under the guidelines there would be £566. But if you could afford that sort of money, you would probably not bat an eyelid. But say the work was being done by a solicitor or legal executive with less than 4 years' experience, and that work was being done in Bournemouth or Grimsby, just examples. The guideline rate there would be £196 an hour. That's better. These guidelines will also give you an idea of what you would have to shell out to your opponent if you lost the case or some procedural application on the way and an order for costs was made against you. You can see the guidelines in full online at this address. The Court Funds Office Special Account Interest Rate has changed.
You told us that last time. You're always telling us it's changed.
Give me strength. It changes every 5 minutes. It's changed again. The amount of interest any victim of an accident that has caused some personal injury can claim from the negligent party for financial losses, such as loss of earnings, is based on this interest rate. And that interest is closely allied to the Bank of England's base rate, which, as you know, goes up and down like a yo-yo. To reflect the latest base rate change, the Court Funds Office's special account rate has been reduced by 0.25% to 4.75% as from the 6th of December 2024. For those who are passionate about the rate, you'll see below a record of the various changes which have taken place since June of 2020. As delicious as ever, this time I would recommend consuming the rates with a small whiskey. A court claim can be struck out if the claimant hasn't followed a court order or rules of procedure. The claimant can ask to be forgiven. That involves what is called an application to a judge for relief from sanctions. In deciding whether to forgive...
You mean whether to grant relief from sanctions?
I do. In deciding whether to forgive, Should the court spend any time investigating the merits of the case, looking at the strengths and the weaknesses of the claim or the defence? Well, in this case, just before the Court of Appeal, it was ruled that the answer was generally no. Otherwise, every procedural application would turn into an expensive and laborious mini-trial, said the Court of Appeal. Of course, the court will want to know what the case was about, but generally it will be unnecessary for the parties to deploy extensive evidence designed to show that they have a strong case on the merits. In the exceptional event that the court would be prepared to look at the merits, the Court of Appeal has directed the procedure that's to be followed. Court proceedings relating to children and finances on divorce are usually in private, and what can be reported by the media, if anything, is strictly controlled. But the media says,
all this behind closed door stuff is bad for our pencils and notebooks. We want transparency.
And there is a drive for transparency. Trials have been going on at some courts with journalists and legal bloggers being allowed in to certain of these private hearings and being allowed to publicise what's gone on, but not anything likely to identify the parties or any children involved, or indeed to say or write anything that the court thinks should be kept out of the public domain. Now, things are really taking off. From the 27th of January 2025, these reporting arrangements are being extended in care cases to all courts, except where lay magistrates are conducting the hearing. Child cases brought privately by the parties rather than by the local authority in care cases, they join in from the 1st of May 2025, again unless lay magistrates are involved, and from the 29th of September 2025, even the magistrates' cases will be involved, both care cases and private child cases. And from the 29th of January, a similar scheme is extended to all family courts in their dealing with financial remedy cases on divorce, with identities also being banned. The financial dispute resolution appointment, at which the possibility of a settlement is investigated, is excluded from the scheme. Now, if you're a lawyer or party involved in one of the affected cases and a reporter or blogger turns up to sniff out what's going on, you'll be invited to make any representations you wish about what order the court should make on prohibiting any aspects of the case from being reported. In fact, you will be extended the right to argue for the reporter or blogger to be sent away, as the court does have a discretion to keep them out. Incidentally, these changes are distinct from the current row over whether, in the tragic case involving Sarah Sharif, who was murdered, and other children, the identities of the judge or judges who were once upon a time involved in deciding their future welfare should be made public. The ban on identification is being challenged in the Court of Appeal, with a decision currently awaited.